Hi, I'm Professor John Blakeman from the UW-Stevens Point Political Science Department, and I'd like to welcome you back to my ongoing lecture series on the U.S. Constitution, sponsored by the University of Wisconsin-Stevens Point Alumni Association and their Alumni College Experience. So this is lecture number 8 on the Supreme Court case Gibbons versus Ogden. So the question you have to ask yourself is, when was the last time I rode on a steamboat? Yeah, steamboat. I think I rode on a steamboat at Disney World back in the 1970s. Not exactly sure. But Gibbons versus Ogden. Who gets to regulate steamboats on the Hudson River? The state of New York or the federal government? And why is this even a constitutional issue? I mean, steamboats are steamboats, right? Well, let's get into the case to find out. So it also concerns state power too, I should say. And so here we have the state of New York in the early 1800s has granted a monopoly to Robert Livingston and Robert Fulton to operate steamboats on the Hudson River. And as the state of New York sees it, that monopoly includes the right or the license to operate a steamboat from New York City to New Jersey and back. So Livingston and Fulton, they have the monopoly, remember, per New York law. They turn around and sell a license to Mr. Ogden to operate a steamboat between New York City and various ports in New Jersey. So remember, they have the economic monopoly granted to them by the state of New York. They turn around and sort of sell part of that monopoly to Mr. Ogden. I'm not quite sure why. Now, one reason the state of New York might have this kind of economic policy in the early 1800s, a lot of states do back then. A lot of states are selling or granting monopoly licenses to businesses to do certain economic things, like operate a steamboat or operate an express coach from one city to another, or to help build a sewer system or whatever. It's partly because states themselves don't necessarily have the revenue to provide these public services. And private investors aren't necessarily willing to take the risk unless the state provides some kind of guarantee. And so what New York State is doing with a monopoly license to Livingston and Fulton, it's effectively guaranteeing to those two men that they will have an exclusive right to operate steamboats. And that right, it's exclusive, so they can exclude other people from operating steamboats in the same place. So the risk issue is sort of guaranteed by the state of New York's monopoly. Then you've got Mr. Gibbons, who comes along with his steamboat. He has a license granted by the federal government under a 1793 federal law. It's called a federal coasting license. And it's a license to operate seagoing vessels, waterborne vessels on the nation's coastal waterways. And so he starts to operate his own steamboat between New York City and Port Elizabeth, New Jersey. And of course, Livingston and Fulton and Ogden are eager to exclude him from competition. And so Ogden sues, and New York state courts uphold Ogden's license over Gibbons. One way to think about this is New York state courts are saying, yeah, the New York license takes priority over the federal license. And hey, this gets us back to McCullough versus Maryland when you think about it in the issue of states' rights. All right, so the questions the Supreme Court has to deal with. Does Congress, under Article 1, Section 8, have power to regulate the nation's waterways? If so, what is the extent of that power? Okay, so let me get the case up for us here. So in Gibbons versus Ogden, we're still talking about Chief Justice John Marshall, the great Federalist. 1824, he's going to be on the Supreme Court for 11 more years. He served a long time. Really had a profound impact on how American constitutional law developed. Actually, this case isn't all that difficult, all that tricky. It ultimately comes down to what we call the Commerce Clause power of Congress, which is in Article 1, Section 8. And we'll get to that in a minute. Marshall explains a few things about the Constitution to us yet again. He says, this instrument contains an enumeration of powers expressly granted by the people to their government. Remember, he's reminding us that the Constitution comes from the people of the United States. The state of New York says, yes, but you've got to construe or interpret those powers strictly, narrowly. Sort of like Maryland's argument with the necessary and proper clause, right? But Marshall says, why is that? Why ought they be so construed? Is there one sentence in the Constitution that gives support to that rule? In the last of the enumerated powers, and what Marshall means is, take a look at Article 1, Section 8. Read it to the very end. In the last, that which grants expressly the means for carrying into execution all other powers, Congress is authorized to make all laws which shall be necessary and proper. This limitation on the means which may be used is not extended to the powers which are conferred, nor is there one sentence in the Constitution which has been pointed out by the gentlemen at the bar, the lawyers for the state of New York, or which we have been able to discern that prescribes the rule that we interpret the Constitution strictly. Wow. So Marshall says, hey, there's nothing in the Constitution that says we interpret the powers of Congress strictly. Nothing. Now, you can disagree with him for sure. Nothing wrong with that. But he's sort of setting the stage for constitutional interpretation. He says, the men whose intentions require no concealment, the framers of the Constitution, the enlightened patriots who framed our Constitution, and the people who adopted it, must be understood to have employed words in their natural sense and to have intended what they said. We know of no rule for construing the extent of such powers other than is given by the language of the instrument which confers them. So, a couple of things. Marshall's reminding us that the framers of the Constitution acted in good faith. The people, when they approved the Constitution, had definite ideas about how it should be interpreted. And the interpretation of it is in words in their natural sense. Natural sense, not necessarily their strict sense, I guess. And we know of no rule for construing the extent of such powers other than is given by the language of the instrument which confers them. So, here he gets to the specific power at issue. The federal government says it can regulate coastal vessels, it can regulate the nation's waterways, because it falls under Congress's power to regulate commerce. This is what we call the Commerce Clause. Very simply stated, Congress shall have power to regulate commerce with foreign nations and among the several states and with Indian tribes. Now, briefly, the reasons for the Commerce Clause. If we think about the young United States up to 1788 and 1789, especially under the Articles of Confederation, each of the 13 states often operated its own trading relationship with other countries, especially the great European powers, Britain, France, Spain. And that really prevented the young United States from developing a strong national economy. And so the framers at Philadelphia in 1788 wanted to correct that. And they wanted the national government, especially Congress, to primarily be in charge of trade, commerce, economic relationships between the United States and foreign countries. And they also wanted the United States government to have the power to develop a national economy or commerce among the several states. So there's a reason for that power. And the reason is based on our historical experience, even prior to the revolution and all the way up to 1787, 1788, and 1789. Now, Marshall says the subject to be regulated is commerce. And our Constitution is one of enumeration. The powers are enumerated. The powers are spelled out. It becomes necessary to settle the meaning of the word. So, right, here we go again, right? We're focusing on one word and what that word means. And we have to settle the meaning of the word. Just like in McCullough, we had to figure out what that one little word necessary meant. Now, here we are again, trying to figure out what commerce means. And the counsel for the appellee, let's just say the state of New York, says commerce is limited to traffic, buying and selling, or the interchange of commodities. Basic trade from one person, one business to another. That's all the commerce power encompasses. It does not comprehend navigation. And Marshall points out this would restrict a general term applicable to many objects to one of its significations. Commerce is traffic, Marshall says. Yeah, I agree with you there. But it is something more. It is intercourse. It is a process. It describes the commercial intercourse, the process of economic relations between nations, parts of nations and all its branches, and is regulated by prescribing rules for carrying out that intercourse. So Marshall says commerce is more than buying and selling, exchanging commodities, and the trafficking of commodities. It is intercourse. It is a process. And as he says, the mind can scarcely conceive a system for regulating commerce between nations which excludes navigation, and which is silent on the admission of the vessels of one nation into the ports of another, and confined to prescribing rules for the conduct of individuals in the employment of buying and selling. So Marshall says the commerce power extends to navigation. It doesn't make sense if it does not. Now, further down, Marshall continues on, to what commerce does this power extend? What exactly are we talking about? The Constitution informs us commerce, remember commerce is intercourse, it's a process of economic exchange. You're going to think about it like that. The Constitution tells us commerce extends to foreign nations among the several states and with Indian tribes. So think about it like this. Congress's power over commerce extends to the regulation over three things. The regulation of trade between the United States and foreign nations, the regulation of commerce or trade among the several states, and regulation of trade or commerce with Indian tribes. It has, we believe, been admitted that these words comprehend every species of commercial intercourse between the United States and foreign nations. So what Marshall's saying is, okay, let's look at this clause, the Commerce Clause. We all agree that Congress has very broad authority to regulate every species, every type of commercial intercourse between the United States and foreign nations. We agree on that. No sort of trade can be carried on between this country and any other, he writes, to which this power does not extend. So Congress has, one way to think about it, Congress has comprehensive, what we call plenary, complete power over trade and commerce between the United States and foreign nations. And Marshall says, if this be the admitted meaning of the word in its application to foreign nations, it must mean the same thing throughout the entire sentence. So what's he mean by that? Well, think about it like this: the Commerce Clause. Congress has the power to regulate commerce with foreign nations, among the several states, and with Indian tribes. The word commerce is used once in the sentence. Okay, so this gets us back, to Marbury versus Madison, phraseology of the Constitution, where words are in a specific clause. The word commerce comes at the very start of the Commerce Clause, and it's extended to cover foreign nations, states, and Indian tribes. So Marshall is basically saying the word commerce means the exact same thing throughout the entire sentence. It does not have a different meaning for trade with foreign nations, a different meaning for trade among several states, and a different meaning for Indian tribes. It means the same thing. It must carry the same meaning throughout the sentence, as he says. Okay, so what Marshall is doing is he's giving the Commerce Clause and the word commerce a very broad reading. It is intercourse, commercial intercourse, a process of exchanging goods and services, of trade, on and on and on. It's very, very broad. And the commerce power has the same meaning throughout the entire clause. So if we agree that Congress has very broad power to regulate commercial intercourse with foreign nations, we also have to agree that Congress has very broad power to regulate commercial intercourse among the states and between with Indian tribes. Now, let me just go back to one thing. Among the several states, there are subsequent Supreme Court cases, which we are not going to get into, where we've got to figure out, well, what does among mean? Does it mean commercial intercourse from one state to another? Between the states, Congress can regulate commercial activity between the states, but not within the. What does it mean? Well, that's a different day altogether. We're not going to worry about that. Marshall does help us maybe figure that one out, though. He says, in regulating commerce with foreign nations, the power of Congress does not stop at the jurisdictional lines of the several states. It would be a useless power if it could not pass these lines. The commerce of the United States with foreign nations and that of the United States, every district has a right to participate in it. The deep streams which penetrate our country in every direction pass through the interior of almost every state in the Union and furnish the means of exercising the right to engage in commerce, the right of Congress to regulate commerce. If Congress has the power to regulate it, that power must be exercised whenever the subject exists, the subject of commerce. If it exists within the states, if a foreign voyage may commence or terminate at a port within a state, then the power of Congress may be exercised within a state. This is really important because New York did try to argue that, okay, Congress has commerce authority over or among the states, but that power stops at the borders of a state. It does not go into the interior of a state. And Marshall's saying, no, that's not it at all. Congress's power does not stop at the borders of a state. It extends into a state. And it can be exercised within the territorial jurisdiction of several states. So we come away with a very broad reading of Congress's Commerce Clause authority. It certainly covers navigation. It covers the nation's waterways. And the power of Congress does not stop at state lines. It extends into the interior of a state. One final thing. What is the power? Well, Chief Justice Marshall says it's the power to regulate it, to regulate commerce, to prescribe the rule or rules by which commerce is to be governed. What he might mean by this is the rules of trade, weights and measures, for example. Actually, Congress has that explicit authority to regulate weights and measures. So a pound is a pound, an ounce is an ounce, a dollar is always worth a dollar. Well, actually, that's sort of coining money and regulating its value, but same thing. Weights and measures, rules and regulations, excuse me, about how commerce is to be conducted. That's what the power extends to. Okay. Now, Marshall says, but states don't need to worry here. One final thing, I think. States still have a lot of authority. They have not surrendered authority to the general government, power over things like inspection laws, quarantine laws, health laws. The internal commerce of a state and those which respect turnpike, roads, ferries, are part of this. So Marshall is, in a sense, he's trying to hedge his bets, if you want to think about it like that. He's saying, on the one hand, Congress does have complete power over commerce among the states. The power of Congress is the power to regulate. That power can be extended into the territory of a state, but states retain several powers on their own. They retain the power to inspect goods that come into their state. They retain the power to put in place quarantines. You know, so think about it. In New York City, New York State, you've got a lot of passenger ships pulling into your harbors. Are those passengers ill? Do they have a certain disease, a smallpox, for example, measles, tuberculosis? States can quarantine if they need to. Marshall's quite clear about that. States can regulate health. He's quite clear about that as well. So as Marshall sees it, economic activity that is solely within a state might be off limits in some circumstances to federal regulation. And then there are certain things that states have not given up. Public health powers especially. They retain those. Now, you know, by the time we get to the 20th century and we talk about inspection laws and quarantine laws, and hey, in the 21st century too, no doubt, there is going to be conflict between federal policy and state policy, no question about that. And it's often federal courts that have to sort that out. That's a different story altogether. But I think what Marshall's trying to remind us is states haven't given up everything. Even though Congress has very broad power over commerce, states still have their own independent authorities to regulate certain things. Okay, so the case is fairly straightforward. I think that maybe that's all that we need to cover. I did give you a concurring opinion by Justice Johnson. I'm not going to go into that. You can read through it if you want. I'll mention the concurring opinion, just the fact that it's here though, okay? All the way up until the 1820s, it was incredibly rare for justices, individual justices, to write concurring opinions or dissenting opinions. The Supreme Court, for its first 30 years, had really developed a model that the court speaks with one voice. By the 1820s, we're starting to see justices write concurring opinions, even some dissenting opinions. By the time we get to the mid-1800s, dissenting opinions are becoming a little more regular. You know, and what that means is early on in the court's history, the court spoke with a united voice. By the mid-1800s, the court is starting to show some basic divisions. I'm not saying Justice Johnson's concurring opinion here is divisive. It really isn't. He just sees the issue a little differently. but it is an indicator that the justices themselves are perhaps becoming a little more independent-minded. One final thing, and we'll leave Gibbons versus Ogden here. Marshall ends by bringing us back around to constitutional interpretation. And he says, powerful and ingenious minds taking as postulates that the powers expressly granted to the government of the Union are to be contracted or limited by interpretation, construction, into the narrowest possible compass, so that the original powers of the states are retained, if any possible construction will retain them. He disagrees with that. He says, they may so entangle and perplex the understanding as to obscure principles which were before thought quite plain. I think what Marshall is suggesting is, let's be very careful about narrow interpretations of the Constitution that protect the original powers of the states. Let's think in terms about the principles of the document, and let's not obscure those greater principles. Okay, well, thank you again. We have one more case in this section on congressional power. It's actually a 20th century case, so maybe you'll be happy about that. So anyway, I'll see you then. Thank you.